2-001-242. The defendant's presence has previously been waived. Go ahead.
Attorney Kay, on behalf of the state, for the record, the victim and next of kin are appearing virtually.
Gerald Bradley, Danae Suki, Jeremy Caulfield representing the defendant. She has waived her appearance as noted by the court.
All right. Thank you. Have a seat. All right. I think the defense wants to make a record on camera coverage, but before we do that, I will instruct the person operating the camera not to zoom in on any documents or the defense table or, for example, Mr. Caulfield's folder that he has in his lap. I don't want any work product to be inadvertently captured by any camera. Thank you.
Yes, Judge.
Go ahead.
Is it okay if I stay here, or would you like me to approach the podium?
No, you can stay there. Just as a basis, I think, maybe to tailor your argument, the court Fox 10 News has made a camera request, as far as I can tell, to every hearing that's happened in this case. And at this point, I consider it an ongoing request for the rest of the proceedings. Obviously, that can change down the line. For example, jury selection, that may not be allowed. So I'm considering it's an ongoing standing request that I'm granting over the defense objection. I did get the objection Mr. Caulfield filed yesterday. I've reviewed that, but go ahead and whatever record you want to make.
Well, Judge, before I do that, a few housekeeping rules that will inform my argument.
Okay.
Are you offering me an argument because that's in compliance with your interpretation of Rule 22, or is it more of a courtesy for me to make a record?
It's for whatever record you want to make.
Okay, so it doesn't have to do with our argument that Rule 122 required it.
Correct. Well, no, 122 requires it, but at this point I'm considering not each request for each hearing to be a separate request. I'm considering it that going forward for every hearing, it's a standing order that the media is allowed into the hearings.
Okay, Judge, and I'll get to that, but just for this particular moment, correct me if I'm wrong, it sounds like you're giving me the courtesy to make a record, but you don't feel like that's required under Rule 122 in this situation. Is that accurate?
Create whatever record you want.
Okay, that doesn't really answer the question, though.
Go ahead.
So you're not going to answer the question about whether...
I think I've answered the question.
Okay. Judge, can you let me know the date and time the camera request was made? It's referenced in your minute entry, but we don't get an actual date and time. You said you...
I don't have it in front of me, but as I recall, I think it came in, maybe my JA can help me out, but I think it's Tuesday sometime. It came in through our media request person, who's Mr. Finari, who's seated in the back of the courtroom right now, actually. Do you have that information, Mr. Finari?
Judge, it was Tuesday at around 2:25 or so that we received it.
All right.
Thank you for that. And Judge, another thing that's going to inform our argument and create a complete record is, as we've discussed through briefings, what happened at the last time was the court's team, Microsoft Teams footage was broadcast against the spirit and intent of your directives and order regarding the 8 a.m. hearing.
Correct.
There's still, at least for me, some questions about that, and I would just ask if we know the answers, we can put them on the record, or ask somebody that might be here to inform us. We need to know who gave that team's footage to the media, because that's directly related to the violation of your order.
I don't know who gave it to the media.
You don't? Okay. So I imagine the media knows. And I don't know if there's someone here that could perhaps inform the court, but I think that's pretty important. And if this is a violation of a court order that, without a doubt, continued to damage my client's free trial and due process rights, because as we know, this hearing wasn't supposed to be broadcast in that manner, and the usual comments and articles surrounded that, and that's all prejudicial information. So how that happens is really important, because I need to address that, and if I need to file something further on that, or I don't, I need to know. So I don't know what you want to do, Judge, but I would ask that you ask anyone who's from the media to fill us in on those details. Now, I can file something if I need to. It might just be quicker to do it this way.
You can do any investigation that you think is necessary through any course that's necessary, but I don't know anything about what the media has or doesn't have other than what's in your motion. So I don't have any knowledge of what was broadcast, what wasn't broadcast. All I know is what you made me aware of in your pleadings, which apparently we suspect one of the next of kin or named victims recorded or screen recorded the team's meeting. What happened after that, I have no idea.
Well, Judge, it's troubling to me that this is a violation of your court order, and it doesn't appear the court wants to explore that any further and is fine with the ambiguity of that violation of the court order. I'm not, because it violates my client's constitutional rights, and I think...
How does it violate your client's constitutional rights?
There was the 8 a.m. recording against your wishes, as you put in your own minute entry.
I don't know that it amounts to a violation of constitutional rights as opposed to a violation of my order about not recording that particular hearing.
Well, the violation of the order directly leads to the violation of the constitutional rights. I don't know how there's not any argument that
What constitutional right was violated?
Judge, the jury is further tainted by all the information that came out in these articles, in this posting of this video that wasn't supposed to be posted. And I don't think that's, I don't understand how that part's up for debate.
Well, your argument is the jury pool has been tainted, not the jury has been tainted. The remedy for that is doing a robust voir dire examination of all the jurors that come in, and that may take some time because of the media coverage that's happening here. We can't assume every person in Maricopa County has been exposed to the Lori Vallow case.
Well, Judge, that's a straw man. I never assumed or said that.
You just said the jury's been tainted.
The jury pool...
No, you said jury.
Then I misspoke, and I'm sorry. The jury pool has been further tainted. Everybody in Maricopa County? No, I'm not saying that. But surely, I think we can agree, people, probably a large amount of people, as we can tell by the, I'll rest on my sealed filing, but views, likes, things like that, have seen this. And they're part of the jury pool.
And that's why we have the voir dire process.
Well, Judge, I think my concern is that's sort of the out for constitutional violations, any concern about the defendant's fair trial rights, is that, well, it can just all be taken care of in jury selection.
Well, I guess, let me ask you this. What remedy would you have me do? I can't tell the media how to report the case. I can't tell people how anything of that matter. So what remedy are you seeking?
Well, Judge, I don't have all the information, so that's why I was kind of asking that question, because it's hard for me to ask for a remedy if I don't know who's fully responsible for this. So I don't know that. So I guess I'm going to have to do my best to figure it out on my own. But there's so many remedies, and that's why we're here every court hearing, that the court can take to at least mitigate the damage that we know is going to happen every hearing. And nothing ever happens. Suggested not recording the hearing or portions of the hearing. You know, Judge, there's things like allowing the defendant, if she wanted to dress in street clothes, which we know she's being forced to come in jail attire if she does want to appear here, which I understand. But since you asked for an example of things the court can do, and that's without banning the press or reporting on the case, I've never said I expect you to tell the press how to report the case. Would never do that. So those are a couple of examples, but there's many more. Rule 122 lists plenty of those examples.
Okay.
Well, that said, Judge, I mean, I would ask for it to be put on the record who is present on the team's recording, since it's still a bit of a mystery how what happened last time happened, so I think it's important to know who's there. And the court may say, well, the names are listed there, which I can't see right now, but we've all seen videos of people who whether it be by accident, well, usually it is by accident, but their name does not necessarily reflect who they are. So I just think it's important to put on the record who's on the team's recording, so if this should happen again.
I can tell you what names appear right now. Is that what you want?
Absolutely.
My name appears, my JA's name appears, my clerk's name appears, my courtroom assistant's name appears, someone named Brandon Bordeaux appears, someone named Kay Woodcock appears, and someone named Susan Vallow appears. That is the extent of the people that are logged in right now.
Thank you for that. Are you comfortable, Judge, just letting everybody know they're not allowed to record the team's recording and give it to the media?
Well, that was only limited to the recording, that we were having a hearing on whether or not media and cameras would be allowed in the courtroom. I didn't make that going forward. I mean, I can make that if you like. I don't know that is that what you were asking?
Well, yes, Judge, considering what happened last time, I'm most definitely asking for that.
Well, that was a hearing that was closed to the media and shouldn't have been recorded.
That's exactly my point.
But this is not the same type of hearing. But if you want me to, I'll tell those people that are online they shall not be video recording or somehow recording the team's feed. Does that satisfy you?
It does, Judge. But you do bring up a good point, and that is this hearing is then a distinction from the 8 a.m. one from last time. Is that fair?
I agree.
Judge, I do want to make clear, we do not have a standing objection to media camera requests. We never have. We have never said that we do. Now, I understand your minute entry said you view that, so I'm not sure you're saying that's what we
Okay,
said.
if you don't, you don't. That's fine.
Well, I want to make it clear on the record because there's a minute entry that seems to imply maybe we have, and we did. And what I did was I wanted to make sure that I didn't say something that could have been misinterpreted to make
You
that
didn't.
position.
That was my assumption.
Okay.
Because since you've been on the case, you've objected to every media being present. So my fault for assuming that you would continue to object.
That, Judge, that's another straw man. That is not my point. You're correct in assuming I will object. You're incorrect in assuming that it would be the type of objection where I just do absolutely nothing, you put it in your minute entry, and I show up and we just move along.
No,
Every time I've
that's-
objected,
That's not what I said. I'm assuming you have an objection. I understand the reasons for your objection could change. More evidence could come forward that you believe is tainting the jury pool could come forward, and you may want to supplement your objection. That's all I was trying to say.
okay, Judge, that is not how it read to me in the minute entry. So I just do want to make clear, every media camera request, we want to be notified, and if we do object, there's going to be a filing, because like you said, and we know in this case, after each hearing, there is new information to consider. Now, you don't have to consider it, but it's my job to at least present it to you, and hope you will. And this is a perfect example. What happened with the team's coverage in the last hearing? That's absolutely new and vital information for at least the court to consider. There was a violation of the court's intentions, and a video that wasn't supposed to be posted damaged my client's rights. So I need to be able to file something in detail about that.
I'm not preventing you from filing anything.
I'm just letting you know because my interpretation of the minute entry was well, maybe I'm wrong, but that was sort of the hope that we would just.
No, it wasn't the hope. The understanding was I felt that you would continue to object, and I understand why you would continue to object. You can supplement your objection as you see fit as we go forward.
I understand that, Judge. There's another problem, though, with minute entry, and we weren't given an opportunity to object under Rule 122. And the court based their ruling on a minute entry on an unrelated motion that the court filed on September 3rd. I assume you know the motion I'm talking about?
The minute entry that sets forth the strong presumption of having the public have access to hearings, yes.
That was in response to a motion I filed that made very clear it was not about Rule 122 and was about the FTR.
I understand what it was about. It was about the FTR.
Okay, well, my problem then, Judge, is if you understood what it was about, it couldn't be the basis for ruling against an objection that never even happened.
You want me to copy and paste the ruling from Wednesday into the ruling to Thursday, I can do that instead of referencing it.
Judge, you didn't even let us have a chance to have you consider anything in this particular hearing. Now you can, and it sounds like you will, but that's prejudging the case. You're not letting.
That's because I'm considering at this point, as I said when we started this hearing, that the media request is an ongoing. I've granted it as an ongoing. They don't even need to request it going forward.
So
Fox 10 News.
So no matter what we file, it's not going to matter. That's how it sounds.
I didn't say that. I said you can file and supplement your objection depending on what you object to and what more information comes out. That ruling could change in the future. But at this point, it's a standing ruling that Fox 10 News can have a camera in the proceedings going forward until it changes.
And Judge, you're not at all wanting to explore if Fox 10 had something to do with the violation of your intentions and the spirit of your directives at the last hearing. And you don't want to address that with them at all.
No. And let me clarify that. Whatever someone did with that recording that was a violation of the hearing, however that got disseminated to, once it's disseminated, I can't control that. I can't control who rebroadcasts that, of what media, whoever.
Judge, you have a lot of control. You can't control whoever the person was who did that. But the media, who is here every time and is a non-party in this case, you absolutely have some control. You can, I see you shake your head.
I don't think I do.
I think you
It's
do.
called prior restraint. It's called First Amendment rights.
Almost everything in the September 3rd minute entry that supports what you just said also has an exception in it. Rule 9.3b does. Rule 122 is an exception. You absolutely have the power to restrict if you see fit and if you see.
I could restrict the initial recording, or whether or not there's recording in the courtroom. What happens with those recordings after people take them or they've gone out, I absolutely have no power over.
But here's the problem. The media was aware of your court order. They were sitting here in the courtroom. So I'm not saying anything about if one of the alleged victims did that. I'm not talking about that. But the media, they're in a different situation. They're to be aware of your court directives. They're to follow your court orders. And if there's any question about what they're doing could be in violation of that, I would hope they would take a pause and talk to legal counsel. Maybe that happened here, but it would have to have been really, really quick. The thing gets posted right away, and as you said, it's a violation of what you had wanted.
Okay.
All right. And Judge, again, I do think that the next time there's a camera request, everyone needs to be, even the state needs to be given an opportunity to object. Now they may not, and they haven't, but that could change. So I just hope in the future for Rule 122 camera requests, the rule is going to be followed, and we're all going to have an opportunity to give our opinion, and then I think a hearing has to be given under the rule. I'll move along, unless you had any questions about that. All right, Judge. I don't have much because, obviously, this is going to be broadcast, so I'm going to rest largely on what I filed under seal for, I think, rather clear reasons. But I do want to talk about a couple things that I just think we are on the same page about. You can correct me if I'm wrong. Is that the case has received an enormous amount of press coverage. It does and will continue to impact my client's fair trial rights. And further camera coverage makes getting an impartial jury obviously more difficult. To me, that sounds like a clear and present danger to the right to a fair trial, which is listed in 9.3b. I understand, Judge, your point is that, well, I agree with all that, but I don't think it's insurmountable. And I think where the rub comes here is your assertion that it's speculative that there's any significant damage that's going to happen when the jury shows up for this trial. Well, I think it's equally speculative in this case that it's not insurmountable. You might be right, but it's certainly speculative. This isn't one of those high-profile cases where, and I've had plenty of these, there's a lot of news coverage for a week or two, and then it kind of goes away for 3 years. This isn't that, and I think we all know that. You could say it's speculative when I say after this hearing, because the cameras are broadcasting it, there's going to be tons of other prejudicial information that is submitted to the public. And technically, you'd be right. I guess I don't know that for sure. But we know it's going to happen because we know about the case, and at this point, it's common sense. I also think it's rather clear that to continue with this is going to further damage my client's rights. The thing that's concerning about the case, to me, is, Judge, I'm not through the discovery. That probably doesn't surprise you. But I'm at a point where I kind of understand the lay of the land with the evidence, and I think I'm getting a pretty good grasp of the basic issues. And what's clear to me, in both these cases, there is a viable defense if we have an impartial jury and my client gets a fair trial.
I plan on delivering you an impartial jury, and I plan on your client getting a fair trial.
And I believe that, Judge. I do. But I won't rehash my concerns.
Can you tell me what the nexus is that you find between camera being allowed in the courtroom and not allowed in the courtroom as it relates to media? Do you agree that every hearing, whether there's a camera or not, is going to be talked about in the media on some level?
Judge, I would agree that, and I think that somewhat supports my point, actually, that no matter what we do with the cameras, they're going to report about the court hearing anyway. Yeah, absolutely. So why do we need the cameras? Especially for a hearing like this, which, other than this argument, would be really short and pretty inconsequential. So I don't think that cuts totally one way. And the point is, because of the visual aspect of the camera coverage, and you've seen it in the comments, the ones I've cited to you, and maybe you've clicked on it yourself and you've seen plenty of others.
I haven't clicked on it, and I haven't sought out anything in the media about this case. And the only thing I really know in this case really is what you've put in your pleadings.
And that's
I mean,
fine.
I will admit I don't watch news. I look at articles about news on my phone. This case has never come up on my news feed.
It's come up on mine.
Well, probably because you're searching for it on your phone.
True, but when I made that point, it was prior to being assigned this case.
Okay. I have heard generally about the case in Idaho, the conviction, the allegations, super generally. I don't know what the specific evidence was in those cases.
Just, I would encourage you, I can make you do anything, but when I do give you the citations with the links, I'm usually giving you a couple of examples.
I'm taking you at your word of whatever you say the link says. I'll take it to be true.
Okay. Would it be helpful if I added more examples, or I just want to make sure the point is we're agreed on that issue?
We're agreed on which issue?
That
This is receiving a lot of media attention and a lot of it's negative.
I would say
Apparently
pretty much
so.
all of it, but
I don't know.
Okay, well, that's.
I mean, I think it would be fair to say it's your job to probably highlight a lot more of the negative stuff. I don't know if there is positive stuff or not. I don't know.
All right. Let me know if you find anything, but
I'm not going to go look.
okay, I will. I'll continue to do what I'm doing. Sorry, Judge, lost my train of thought here. So I'll largely rest on the motion. One thing I had to ask, which you've already addressed, is to have the cameras not come near our table because of our work product here and things like that, and hopefully that's been complied with. And so I would ask, Judge, for you to order there not be camera coverage for this particular hearing through the media's cameras under Rule 122.
All right. Thank you. Anything the state wants to say as far as that issue?
Your Honor, I just, only because of any appellate issues on the potential prejudice or bias to the defendant, I just quickly Googled the population of Maricopa County is over 4.5 million. The population of Boise, Idaho, where both Chad Daybell and Lori Vallow each had trials with different and unique jury pools, has a population of 237 under that, 1,000. So with 237,000 people in the state that occurred, they were able to get two juries that were unbiased and able to hear those cases with all of the court coverage and with that having occurred in that state as well. And by that I mean the children's homicides were in that state as well as the wife of Chad Daybell. So obviously there will be jurors or potential jurors in the panel who will have heard of this, and that's why we have voir dire, because in any case there are always going to be potential jurors who have heard about the case through the media. And so that is why we have voir dire, and that is why we will be able to strike those individuals who have heard about the case or who are biased by anything they may have heard or read about the case or have preconceived ideas about the case. And so when we talk about prejudice to the defendant, I absolutely think right now we are very much putting the cart before the apple. It's too soon to say that there's any prejudice because we aren't even there. We don't have a panel here. If we had a panel here and every single one of them said that somehow, then we'd get another group of them. So I guess I just want to make sure that it's very clear that I can understand that we want to be very careful when we do get to the point of jury selection. And I think everyone agrees that we want a fair and impartial jury. But to base that upon media that's out there at this point and already start arguing that the jury that will be hearing this case is prejudiced without having picked that jury and instruct those who are prejudiced seems a little forward before that's even happened. And I guess I'm not sure how we can make that argument at this point. That's something, as I think this court said, that should be argued and dealt with when we're picking the jury and not months and months before that.
I will say that I would not be surprised to see a significant number of people in our potential jury when we bring them up that have a negative view or have been exposed to this case, and it will likely take much longer to pick this jury than a typical similar case. So I recognize that challenge, and if we have to bring in 500 people or 1,000 people and it takes weeks and weeks and weeks, that's what we'll do. But we will strike those people that we need to strike.
Judge, if I could have 30 seconds to wrap this up.
Go ahead.
Thank you. Just to be clear, Judge, the argument here is by allowing this continued coverage unfettered, it's further tainting the jury pool. I think sometimes it's characterized that I'm making a different argument. I understand this is a big county, but that said, Judge, as you just noted, there's going to be good prediction. There's going to be significant issues with this jury selection, and I just think that the court and the state, I may be misreading, but should not be as supportive of the media coverage, and there should at least be some attempt to mitigate the damage. What will happen with that attempt? It will have a positive effect. How much, we don't know, but to kind of do nothing, the snowball just keeps rolling and rolling, and by the time we get to trial, it's going to be bigger than it already is. Put it lightly.
Well, I don't support the media coverage. And if I thought I had a legal basis to exclude the cameras, an adequate legal basis to exclude the cameras, I would. Frankly, I personally don't like the cameras in here, right? But based on the case law, absent really extraordinary circumstances, I think I have to have them in here. And I know you'll argue these are extraordinary circumstances. But I think I've ruled in accordance with the law. Can we move on to why, the other reason we're here, the complex case management conference? I have received the complex case, joint case management report. Mr. Bradley, it seems to indicate you think you're, at this point anyway, on track for a trial date.
I certainly wouldn't say I'm not. I've got still quite a bit to do, but I've been making great progress, and it seems possible. Yes, that's my goal for sure. I have
Okay.
no reason to want to prolong this particular trial.
Any discovery issues you need assistance with, or you need to bring to my attention?
Not really, Judge. There was a legal issue that was pretty important, and I did ask the state about it, and they did provide an answer. So I appreciate that. But no, not at this time. A part of the problem is, Your Honor, there's over 100,000 pages here. There are times when I find something deep into it that, like for example, I'd asked for the immunity agreements for various people, and just the other day I saw it wasn't signed and it wasn't everyone's, but it wasn't something I realized I was there until I'm tens of thousands of pages into it. So just putting that on there.
Okay.
Just for the record, Your Honor, those are immunity agreements given by Idaho, not by the state of Arizona.
All right.
And Judge, I could be wrong, but I thought, and again, it wasn't signed, but I thought the Maricopa County Attorney's Office was involved in at least one of the immunity agreements, but I guess we can talk about that another time.
Your answer is no, that the county attorney's office?
We have not provided immunity to any witness.
All right, so another complex case management conference in about 60 days would put us in early November with a trial date in February. So I would assume at that time you'd probably have more idea how viable that trial date is.
I would definitely agree with that. I was thinking maybe 45 days, but
That's fine.
I can work with 60.
45, 60, whatever you want.
45 would be good.
All right. Drea, do we have something on October 18th for an hour?
It's blocked for training.
Okay. The 25th is JED, right?
Yes.
What about how about 1:30 on the 26th? That's a Thursday. Wait, no, it's not.
Like that's
The
a Saturday.
24th, sorry. I was looking at September. 24th of October.
All we have are 8:30s.
Why don't we set it for 1:30 on October 24th? Does that work for everyone?
That works for the state.
Yes, Judge.
No, Judge, hold it for an hour.
Yeah, lock it for an hour. Do you want your client's appearance waived for that?
Yes, Judge. We would ask that our client's appearance be waived for that hearing.
All right, that's granted. Anything else from the state,
No, Your Honor.
from the defense?
Two things, Judge, short ones. Would the court grant our motion to seal the most recently filed objection?
Yes.
Thank you. Second one is just a clarification. Since the last hearing, an attorney from Maricopa County Sheriff's Office filed a motion on the street close motion, and then I did file a reply. I was a little unsure if that was still in play. Anyways, my understanding, and you can correct me if I'm wrong, is that the court is ordering that if Ms. Vallow appears in court, she will have to wear her tail attire.
Correct. other than jury selection and trial. Yeah.
Thank you.
Anything else?
Nope.
We'll be recessed.